The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Thanks for joining us today for an orientation to the draft policy guidance for residential adaptation to sea level rise. My name is Mary Matella, and I'm an environmental scientist at the Coastal Commission, and I'm joined here by other members of the Commission's Sea Level Rise team in San Francisco. I'll begin with an overview of today's presentation. I'll talk a little bit about the background of the project and the process of preparing the draft guidance. I'll then present a summary of the new draft guidance contents and how you can offer comments. I'll conclude with our plans for next steps, and then our team will take any questions that you might have. Note that the draft document I'll be presenting is posted with the staff report on the August Commission hearing agenda for Wednesday. The link is on the screen here. This same orientation will be given next week at the hearing. Due to the number of people on the call, we will not open the lines for verbal questions. Please enter comments or questions in the questions box of the web interface so that we can try to be ready to answer as many questions as possible after I'm done presenting. Note that this webinar will also be recorded and posted later. So now I'll share some project background. The document is a product of the Coastal Commission's fiscal year 2014 NOAA Federal Grant Project of Special Merit. The overall goal of this project is to ensure that shoreline development and redevelopment is resilient to coastal hazards while maximizing protection of coastal resources such as public access to the beach and shoreline, recreation, visual resources, and shoreline ecology. The final product will be adopted policy guidance that is intended to assist local governments in planning for sea level rise adaptation for residential development. This project also builds on and complements the Commission's sea level rise policy guidance adopted by the Commission in August of 2015, and it supports achievement of numerous strategic plan action items, objectives, and goals. So I'd like to begin framing the sea level rise challenge that this draft guidance aims to address for residential development. This draft policy guidance focuses on residential development because it is one of the most prevalent community development patterns along California's coast and poses one of the more frequent hazard management challenges today. As sea levels rise and beaches migrate inland, maintaining development adjacent to the shoreline will result in narrowing and eventual loss of beaches, dunes, and other shoreline and offshore recreational areas. This new challenge to public access has the potential to cause significant conflicts with the Coastal Act, which was enacted for the purpose of protecting California's coastal resources. It also conflicts with the public trust doctrine as embodied in other statutes, Article 10, Section 4 of the California Constitution, and the common law. Furthermore, it presents a significant environmental justice issue if residents continue to enjoy shoreline access while the general public is blocked from accessing the shore. So as I mentioned before, the overall goal of this project is to provide assistance to local governments to update local coastal programs, or LCPs, to address sea level rise to ensure that shoreline development, including redevelopment, is resilient to coastal hazards while maximizing protection of coastal resources. The final product will be adopted policy guidance that provides an in-depth discussion of sea level rise adaptation policies specifically related to residential development, accompanied by examples of policies that cities and counties could modify for use in different community and geologic contexts. In the process of developing this draft policy guidance for residential development, Commission staff assessed existing shoreline residential areas and reviewed existing LCP planning documents, mapping, and various data sets to identify and characterize coastal areas of the state. Staff proposed a typology, or classification of shoreline types, to describe the residential development and hazard conditions found along California's coastline. This typology is useful for guiding the application of alternative statewide sea level rise adaptation policies that are consistent with the Coastal Act. The project development was guided by a steering committee of internal staff members, including staff with legal, enforcement, engineering, ecology, and district work experience, and the sea level rise team with subject matter expertise. This group was instrumental in shaping the Coastal Act policy analysis and model policy language. Communication with interested stakeholders through conferences and several years of working with LCP grantees has informed the drafting phase of developing the draft policy guidance. Commission staff will continue to work with local governments and other interested stakeholders to glean valuable input in shaping the policy guidance and model language. We expect the next 8 weeks or so to contribute a substantial amount to our next version. I will talk more about those input opportunities later in this presentation. So here's a quick highlight of important concepts about using this draft document. This guidance is advisory and not a regulatory document or legal standard of review. Not all of the content will be applicable to all jurisdictions, and the content gives a menu of options to use if relevant rather than a checklist of required actions. Model policies need customization for application to individual LCPs. They can aid consultation with Commission staff when local governments are determining applicable policies. There are 7 sections to the policy guidance. The first 6 sections serve as a type of application guide for how to use the model policy language to update an LCP. It describes background on LCP planning, residential development, and the challenges that sea level rise presents for different types of hazards and development, and principles that apply to all hazardous areas, as well as strategies for specific types of areas. Sections on legal considerations, implementation, and case studies then follow. The final section comprises about half the document and presents 7 types of strategies, which I'll discuss more in the coming slides. Staff proposed a typology or systematic classification of types that have similar characteristics to describe the residential development and hazard conditions found along California's coastline. We considered geomorphic setting and development density in categorizing 6 broad types of residential development: urban blufftop, urban beachfront, urban estuary, and low-density blufftop, low-density beachfront, and low-density estuary. We created the typology because each type has different hazard impacts and feasible adaptation strategies. Now, despite the residential typology, there are still some policy types that are universally applicable. While adaptation strategies should be chosen based on the specific risks and vulnerabilities of a particular region or project site, in the context of applicable Coastal Act and LCP requirements, the following broad policies exemplify important concepts for a strong LCP framework for addressing sea level rise: best available science, risk disclosure, avoid hazards through siting and design, and redevelopment regulation. We have 5 best available science type policies that demonstrate model options for integrating best available science on sea level rise into LCP planning through the use of sea level rise scenarios, mapping, and technical reports. All communities should also be considering longer planning horizons and phased approaches that inform property owners and the public about planned adaptation through such mechanisms as hazard overlay zones, deed restrictions, real estate disclosures, and assurances or waivers of rights based on defined triggers sensitive to the particular planning context. Development should be required to be resilient and safe while assuring the protection of shoreline recreational resources and ecological values. Avoiding flooding and erosion through setbacks, siting, and design decisions that locate development at safe distances from potential hazards should be the first consideration for all types of new development. Because many communities have existing development in hazardous areas already, it will be challenging to ensure that redevelopment is also resilient to future hazards, especially because redevelopment occurs incrementally. Redevelopment strategies then are the foundation for implementing many types of adaptation for existing development. These strategies are low cost compared to armoring solutions, and they allow property owners to continue use of their property until rebuilding restrictions phase out high risk and high impact development over time. The planning process includes identifying how and where to apply different adaptation mechanisms based on Coastal Act requirements, other relevant laws and policies, acceptable levels of risk, and community priorities. Here are some broad categories of related adaptation strategies that are represented in Section 7 of the draft policy guidance. Different types of strategies will be appropriate in different locations and for different hazard management and resource protection goals. For purposes of implementing the Coastal Act, no single category or even specific strategy should be considered the best option as a rule. In most cases, especially for LCP land use and implementation plans, multiple adaptation strategies will be needed, and every community will need to assess their risks and their potential options at multiple scales. In light of this need, community-scale adaptation planning policy samples offer ideas for local governments to consider. As a part of the planning process, of course, community visioning and participation in developing an adaptation plan are vital to scoping the appropriate strategies a community will consider phasing over time to address hazards as they become manifest. So here on this slide are some example policies that are in the policy guidance that might apply to 3 distinct geomorphic cases: beach, bluff, and estuary. These could apply in multiple shoreline settings, and they are meant just to illustrate connections of shoreline situation with sample policies. In many cases, a hybrid approach that uses strategies from multiple categories will be necessary, and the suite of strategies chosen may need to change over time to address increased sea level rise and associated increased exposure to hazards. The legal context of various options will also need to be considered in each situation, and ultimately, adaptive responses will need to be consistent with the Coastal Act. So the legal considerations section contains Coastal Act policy analysis in the beginning and gives a recap of some of the public trust background from the 2015 Sea Level Rise Policy Guidance. This version presents additional information about how Coastal Commission and local government public trust authority and duties are now currently understood. Sea level rise adaptation policies may potentially give rise to takings concerns. Because the determination of whether a particular policy or regulation may in some circumstances be applied in a way that constitutes a taking is so fact-intensive and context-specific, this guidance cannot provide a simple set of parameters for when agencies should either allow exceptions to a land use regulation or consider purchasing a property interest. However, the guidance does provide policy recommendations that could reduce the potential for a successful takings claim. Navigating the balance between coastal resource protection and private property rights will require careful consideration of relevant precedent, nexus and rough proportionality, background principles of property law, and distinguishing government takings from takings by the forces of nature. The draft document is also presenting a flowchart of some of the criteria to consider when applying a legal framework to determine whether shoreline armoring is a feasible adaptation strategy for residential areas. So now on to implementation of the strategies that are selected by the local governments doing their LCP planning. The steps on this slide are from the 2015 Coastal Commission Sea Level Rise Policy Guidance, and they provide the broadest framework for addressing sea level rise in an LCP. All communities should step through this framework when planning to update their LCPs to address sea level rise. It starts with choosing a range of relevant sea level rise projections and identifying sea level rise impacts and risks to resources and development, essentially vulnerability assessment elements. Identifying adaptation measures and implementing and monitoring our adaptation steps, and these are generally covered by stages 4, 5, and 6 on the slide. In reality, the implementation of the same LCP steps happens at the project level through these LCP policies. This crosswalk here shows how Section 7 sample policies can fit into the process of comprehensively addressing sea level rise. After identifying appropriate adaptation strategies for each planning area, communities can look to the sample policy compendium in Section 7 for policy language that can help implement those strategies. For protection, look at the building barrier policies F1 through F10. For accommodation, look at design policies C1, or softer natural solution policies E1, E2, and E4. And for retreat, we could look at policies D1 through D3. Community scale adaptation strategies, policies G1 through G11, also encompass many types of adaptation and hybrid approaches. A helpful approach for coastal communities to consider when planning for sea level rise involves phasing in short and long-term adaptation strategies over time. This concept of adaptation planning pathways provides a structure for sequencing adaptation measures using the time horizon of expected sea level rise impacts. Many Section 7 model policies facilitate implementation of this approach. For example, distinguishing between short and long-term actions and triggers are inherent in such policies as G1, removal conditions, G5, beach replenishment, G7, repetitive loss, and G8, beach management plan. The planning pathway approach for a community-scale adaptation also provides a way to manage uncertainty in timing and extent of sea level rise impact by incorporating triggering actions in the planning or implementation stages of adaptation strategies. For example, triggers related to the extent of flooding or frequency of damages might be selected to initiate new phases of adaptation actions, represented here in this slide. Now, these triggers should be informed by local community involvement and will reflect the community's risk tolerance, local conditions, and adaptation vision. The case studies section presents 6 short case studies of coastal communities that have some portion of their coastal shoreline that fits into the groups determined by the conceptual typology to demonstrate how adaptation is currently being approached in California. Let me mention a few of the relevant issues in each. Starting with the Newport Beach example, this exemplifies issues related to bulkheads and public tidelands. The Broad Beach example highlights the testing of hybrid shoreline protection, beach nourishment, and revetment combinations. Solana Beach highlights seawalls, redevelopment, and recreation mitigation policies. Bodega Bay, a low-density estuary, has examples related to wetlands protection and development removal conditions. The Stinson Beach case study notes the integration of FEMA regulations and structural elevation to address sea level rise. Big Lagoon discusses cabin relocations and triggers for structure removal as bluff edges are eroding. So these case studies just demonstrate the variety of approaches being explored for these different shoreline types. So now on to the second half of the draft policy guidance. The model policies are intended to provide guidance for the development of LCP policies with an emphasis on applicability to residential development. Not all approaches listed here will be appropriate for every jurisdiction, nor is this an exhaustive list of options. In addition, looking at a single policy does not indicate how the entire LCP achieves compliance with the Coastal Act. Now, I want to note that local governments structure their LCPs through their land use plans and implementation plans in a variety of ways, with some local governments including significant policy detail in the land use plan, and some reserving such detail for the implementation plan. Some of the model policies in the guidance reflect a more general policy, as most commonly seen in the land use plan, and some have more relevance to implementation or zoning policy, more typically seen in an implementation plan. Local governments should customize the model policies to align with their community's approach. Understanding sea level rise hazards. This category describes model policies to define best available science, anticipated duration of development types, coastal hazard zones, and technical studies required in given contexts, all providing ways to inform risk assessments and planning for the future effects of sea level rise and coastal hazards. Assumption of risk policies and real estate disclosure provide important mechanisms for educating property owners about hazards and their options for addressing them in the future. The policies in Section B are meant to be used together to provide more guidance for new development on vacant parcels, as well as more complex redevelopment in areas with existing residential patterns. The intent of these policies is to site and design to protect coastal resources and minimize risks to life and property to the maximum extent possible, using setbacks, redevelopment definitions, non-conforming structure and land division restrictions in areas threatened by sea level rise. Understanding the more complex redevelopment and takings concerns for some communities, new policies for removal plans and reliance on shoreline protection will be important for proactive sea level rise planning. Accommodation strategies rely on methods that modify existing development or design new developments to decrease hazard risk and thus increase the resiliency of development to the impacts of sea level rise. Design options for accommodation can be an important part of phasing a community's response to sea level rise impacts. The policy sample in our guidance is general, but it could be customized to the applicable hazards a community is confronting. It cross-references another policy for flood hazard mitigation design options as well. The retreat strategies in the guidance are related to removal conditions and retreat management plans. There is also a sample on contingency funds to finance removal if it becomes necessary to modify, remove, or relocate structures when removal triggers are met. The concepts of moving development away from hazards are also present in the Section G policies for community scale adaptation planning. The model policies related to habitat buffers, soft shoreline protection, stormwater impacts, and flood hazard mitigation should be considered for relevant shoreline types. It is also important to note that the term soft shoreline armoring can refer to shoreline restoration projects or to shoreline armoring that includes a natural component, such as a revetment that is buried beneath sand and vegetated. While the former may be permissible as a restoration project in many circumstances, the latter constitutes shoreline armoring that is generally not permitted to protect new development, though it is required to be approved if it is necessary to protect an existing structure or coastal dependent use, and is the least environmentally damaging feasible alternative as required by the Coastal Act. Managing shoreline armoring has been challenging for many local governments because urban areas are frequently made up of both developed and undeveloped lots. In addition, many developments in existence in 1976 have since been redeveloped through renovations, remodeling, additions, and complete demolition and rebuilds. The reality of effective shoreline management is that the Coastal Act and LCPs must address and be applied to a wide variety of physical and legal circumstances that may not be addressed by a simple application of the Clean Coastal Act distinction between existing development that may be entitled to shoreline armoring and new development that is not. In our draft guidance, we present 10 sample shoreline armoring policies that can offer insight into many of the shoreline armoring contexts, laying out the general policies first and then offering details on prioritization, siting and design, mitigation, and expectation for the shoreline armoring in the future. Much of the sea level rise adaptation for residential land use option will require a community approach, as the scope of parcel level actions is too limited to address all coastal hazard impacts, especially when existing residential patterns are already located in hazardous locations. For example, unless individual bulkheads in a community are raised together, the lowest one will be the weak link and expose larger areas, homes, and roads to flooding. Community-scale adaptation plans should also take into account other climate change impacts, such as changes in precipitation patterns or fire frequency, and work with other counties and cities to develop and incorporate expectations for potential future impacts given other watershed-scale changes. These changes may be related to climate change effects, other development upstream, or management decisions and processes. Community-scale trigger-based adaptation approaches present a mechanism by which adaptation actions can be phased over time. These policies should be developed through a community adaptation planning process that specifies appropriate trigger types and responsive actions, such as beach nourishment or programs such as a managed retreat program. Model policies G7 through G9 contain conceptual elements or triggers that could be written into a single customized policy for a particular location. For example, a managed retreat program could use repetitive loss or beach width triggers to set community priorities for targeted buyouts. Additionally, a similar policy to the managed retreat program for beaches could also be applied for wetlands or other habitat areas subject to sea level rise. Now, how you write a policy also depends on the geomorphic and development context each community is planning for. This slide illustrates some different considerations related to bay, bluff, and dune environments, and the sample policies can serve as a launching pad to initiate development of individual customized local government adaptation policies. Another reason customizing language is necessary is that some of the model policies in the guidance reflect a more general policy, as I mentioned before, as you would see in a land use plan, and some have more relevance to implementation or zoning policy, as you would see in an implementation plan. And local governments should customize the model policies to align with their community approach. And again, not all approaches listed are going to be appropriate for every jurisdiction, and the list is not exhaustive. If you find that something is missing when you review the draft document, we would really welcome that feedback. In summary, I'd like to repeat a few key messages. First, updating LCPs to address sea level rise is an important Coastal Commission priority, and this policy guidance is intended to assist local governments in doing so. Some additional take-home points are noted here as well. As sea level rises, proactive adaptation will be necessary to preserve coastal resources on a migrating shoreline. The strongest approach for minimizing hazards is to avoid siting new development within areas vulnerable to flooding, inundation, and erosion, thus ensuring stable site conditions without the need for long-term financial and resource commitments for protective devices. Next, educating shoreline property owners about sea level rise impacts will be vital to adaptation strategies that can be proactive and minimize takings risk. When property owners understand and assume the risks and mitigate the coastal resource impacts of development in hazardous areas, often referred to as internalizing risk, the public no longer bears that burden. A community visioning process and adaptation plan are vital to scoping the appropriate strategies a community will phase over time to address hazards as they become manifest. Protecting public trust lands and resources, including as sea level rises, is important. New shoreline protective devices should not result in the loss of public trust lands. Where allowed under the Coastal Act or the relevant LCP, shoreline protective devices should be sited, designed, and conditioned to ensure that they do not result in a loss of public trust lands or encroach onto public trust lands without the permission of the appropriate trustee agency. The Coastal Commission will continue to provide avenues for and encourage maximum public participation in planning and regulatory processes, and will continue to establish and/or expand non-traditional alliances, such as between and among public and private resource managers, tribal groups, scientists, and decision makers. Share knowledge openly and actively, and regularly and clearly communicate to the public on the science as well as on the range of solutions to prepare for sea level rise. While sea level rise vulnerability assessments and integration to LCP planning will look different across jurisdictions due to the diversity of shoreline development contexts, all communities would benefit from starting an adaptation planning process now to prepare for the long-term resilience of their built and natural resources. So the comment period is now open, and we anticipate that it will close September 15th, and that will give us time for response to comments and revisions. Comments may be submitted by email to residentialadaptation@coastal.ca.gov, and this presentation will be repeated at the August Commission hearing, so tune in on the 9th if you're available then. I'd like to say thanks to everyone who called in today, and I hope that you learned some more about our draft policy guidance. We hope that you review the document, and we look forward to receiving your comments and updating the draft. I think we do have some time now to take questions, so hopefully some folks have typed in questions into the question box during the course of the presentation, and if you have more thoughts about questions that you'd like to ask, feel free to type those into the webinar system now. We have people who are starting to look at those questions, and we will start answering some of those.
Okay, yeah, hi, this is Madeline Cavalieri with the Commission Sea Level Rise team. There's a question about whether the model policies are part of the proposed interpretive guidance. Yes, they are, but I wanted to direct everybody's attention to a table right before the table of contents. There's a table called How to Use This Document, and that explains that the guidance is not a regulatory document. It's not the legal standard of review. This really is a tool to hopefully assist local governments in developing LCP policies that are appropriate for their jurisdictions. The model policies are provided as a model. We expect that local governments will likely modify the policies to fit their jurisdictions, and that not all of the policies would be appropriate in everybody's jurisdiction. There was a similar follow-up question about what we meant by, I think there maybe was a phrase that only use the policies that are relevant to your jurisdiction. And again, this is going to the same idea that the policies are provided as examples, and this is overall a tool to use, but it is not the standard of review. That will continue to be the Coastal Act, or in the case of implementation plans, the applicable land use plan.
Okay, so one of the next questions was sort of related to that slide about adaptation pathways and that sort of example. And the question was sort of around how do different funding pathways and planning timelines fit into that different trigger approach. And I think you're raising obviously a really important point. And I think part of that slide was really just supposed to, be a hypothetical example. To start thinking about how these different things will move through time, and certainly, you don't want a trigger that is hit that influences a decision that you then still need to go through all of that planning process. So the point is to make those triggers early enough that it still allows time for the implementation of those follow-up actions, both of planning and follow-up actions. And in many cases, that might take some more research. It's going to take a lot of information. But I think the point that we're trying to get at now with some of these early adaptation planning processes is to start thinking about how those different adaptation approaches fit together. And if the long-term plan is to do some strategy, you can sort of back out, it would take, 10 years to plan this, so then your trigger has to be related to that planning horizon. So yeah, there is still some information needs in there, but we're just sort of trying to get the sort of approaches, people thinking about these various approaches.
So I think questions are coming in kind of fast and furious now, and we're going to do our best to respond to them. There was one related to which policies can be used to internalize risk. And so I just wanted to talk a little bit about that. The idea of internalizing risk is that property owners, in this case homeowners, would assume the risks and take responsibility for developing in a hazardous location, and that those risks wouldn't be put on the public. The public wouldn't be burdened with future adaptation planning needs on the site. A lot of times with those, we're talking about assumption of risk, requiring the property owner to assume the risks of building there, to indemnify the local government, requiring disclosures so that property owners are aware of the risks that they're facing, and then that any impacts of that development over time, while that development is still there, are mitigated by the property owner. So, for example, if shoreline protection is used, mitigation is carried out by the property owner to address the impacts on the public coastal resources.
So there's one question about sort of in the guidance, are we weighting or emphasizing certain adaptation strategies over others?
Well, we certainly do have a policy that refers to the prioritization of certain strategies. So we would like them to be considered whether or not, the soft shoreline armoring types of approaches could work. And so that is a potential policy to look at to start with. Yeah.
Yeah, and then as far as specific adaptation strategies that we talk about in here, we're not, from our perspective, weighting them better or worse or more useful than others, because that's going to be really based on a sort of community level decision-making process that reflects all the different vulnerabilities and interests that play there. So yeah, I think Mary described this sort of just being a pretty vast library at this point of different types of strategies.
And a community can prioritize what they want to pursue in there.
There's a question about accessing the draft document.
So right now the draft is the exhibit to the staff report that's on the August agenda, and we're going to be preparing another web page that is similar to the Sea Level Rise Policy Guidance web page that will just post various things on it. That's not up yet, but right now the way to get it is through the agenda, the August agenda. It's on for Wednesday, August 9th. There are links there. You can download the PDF.
There's a question, are storms considered by the Coastal Commission as sea level rise? I mean, when we use the term sea level rise, we're referring to the longer term trend of global and regional sea level rise that is caused by, as an impact of climate change. Storms on top of a condition with elevated sea levels contributes to the coastal hazards that we need to plan for. So typically we recommend that not only a local government look at kind of sunny day inundation hazards that could occur over time along the jurisdiction, but also how does that hazard condition change when you add a storm on top of that? So what happens during the extreme event?
Okay, there are a couple of questions about legislative changes to the Coastal Act. Those are, we don't have comments or insight into those. Those are on the legislative track. There's a question about whether roads and streets close to the close to the ocean are under the Commission's purview, and yeah, if they're in the coastal zone, if it's in the jurisdiction of a local government, then any certified LCP would apply. If there's not a certified LCP, then the Commission would have jurisdiction over those roads and streets and other development that's within the coastal zone.
There's a question about sort of balancing the competing needs. So, for example, the need to protect existing development versus a walkable beach. I think a lot of this goes back to just the requirements of the Coastal Act. We are supposed to be maximizing public access and balancing what sort of that means with, different types of development. So we're governed by those requirements in the Coastal Act. And as far as guidance goes, I would point back to sort of more of the conversation in the Sea Level Rise Policy Guidance from 2015. Just relating to, we do understand that there are going to be conflicts between some of these different resources. And that's really the importance of doing this sort of vulnerability assessment and adaptation planning process at the community level. So sort of understanding on a community sort of based scale, what are the different assets that are at risk, and what are the goals of the community, and then how does that all relate to, back to the requirements of the Coastal Act.
The next question is a bit hard to summarize, so I might just read it. It says, does the Coastal Commission have a default position to protect or to not protect concerning residential developments that are closer to the waterline than would be allowed since the Coastal Act? Would the Commission just assume these developments be eliminated over time, or is the Commission neutral and leaving that up to the local LCPs? I think this is a complex question, so I'm going to do my best with the answer, but I think that there are a lot of different aspects to it. In general, the Coastal Act provides Section 30235, which allows shoreline protection for existing development. It was, we described it in that first Sea Level Rise guidance from 2015 as grandfathering in that development. And so when you look at it through that lens, then existing structures are entitled to protection. New structures need to be built in a way that doesn't require future shoreline armoring. That's under Section 30253. So in that way, those new developments would be built farther back away from the beach. And so you can see that the Coastal Act itself sets up this structure of slowly moving development out of hazards way, out of these areas that require shoreline protection. That's built into the Coastal Act itself. This guidance, which is the standard of review, this guidance describes a little bit more and provides some tools for how to address that given the current development patterns. And I think we recognize that there are urban infill areas where we have a development pattern that's existing that needs to be addressed, and the reality of that versus the Coastal Act requirements, I think we struggled. We're working through that and trying to provide guidance to assist local governments who are facing that kind of situation. There's a question, are guidance policies in the works for other land uses other than residential? Right now, they are not in the works, but we are hoping to have some new federal funding to address infrastructure and hopefully develop some policy guidance out of that, but that is not secured yet. So it's certainly on our radar as something that we would like to do, and we are trying to secure funding for that.
There's a question about essentially about how State Lands Commission is coordinating, along with this question about sort of the moving public trust line. That is something we're working on state lands with. We have a grant to work with them on some of these topics. So we are working on that.
And I would also let everybody know that the Center for Ocean Solutions just completed a project. They convened a working group and developed a consensus statement on the public trust and what sea level rise means for the public trust resources and how those need to be addressed moving forward. The Center for Ocean Solutions is going to be at the Commission hearing next Wednesday. They're going to be presenting right before this item. So I would encourage everybody to listen into that presentation and check out the consensus statement. And they also did a background legal document, which is all available on their website. It's a really in-depth review of public trust, and State Lands Commission and Coastal Commission are coordinating on that issue.
There are a couple of questions just sort of related more broadly to funding different adaptation actions, especially when it comes to, the possible need to buy out different structures. That's, I think, something that we all are aware of as a need, and that's something we're going to continue to work with our sort of state agencies and federal agencies as well. For example, we've been working a little bit with FEMA and Cal OES on some sort of different coordination among like the hazard mitigation plan, and some of the FEMA mitigation grant programs could be used to fund some of these different strategies. So we're definitely working on things like those, and I think we're going to, yeah, and I think some of that is talked about in the guidance as well, but certainly we'll be continuing to work on that issue.
And I think to the extent that local governments are dealing with that issue and would like to express it, I think that that's helpful to bring it into this conversation, that funding for adaptation, especially for some of the planned retreat options, funding is a big barrier. And I think the more that that's brought into this public conversation, the closer we'll be to identifying and securing funding for that.
There was one question just about making the PowerPoint available, and I think that's something we can do as well, along with either this recording or some of the recordings from the Commission hearing, for example. So we'll make sure to get that as well. These have really slowed down. Give people a couple more minutes to sort of get in their last thoughts as well.
There's a comment about providing more workshop time with the Commission. So we're going to be kind of looking at all of our options to maximize the public participation in this process and to get as much feedback as we can. So thank you for your suggestions. And we will be looking at what we can. Of course, we have limitations on time and things like that, but we'll be looking at it. Thanks.
I think it looks like the questions have mostly died down, so I think we'll maybe wait a couple more minutes just in case people have final thoughts. Mary, did you want to sort of wrap up anything?
Great. No, I think folks on this webinar can expect to see a follow-up email from us and we will continue to take comments and questions. Again, the residential adaptation at coastal.ca.gov is the email address to use to reach our Sea Level Rise team, and we welcome all of your comments, and tune in to the commission hearing next Wednesday if you'd like to see this again or hear questions and answers again as the commission hears this presentation. And thank you all for your time this afternoon. Appreciate it. Anything else?
I think that's it. Thanks, everyone.
All right. Thanks so much.